appreciate everybody being on here. You know, let's get going. Most importantly, I don't know, Mossy's up on the left part of my screen. I don't know if everybody's on the left. Hey, Moss, anything important to you happen to you in the last couple of days?
Yes.
What might have happened?
I became a United States citizen on Wednesday. So it was a long 27-year journey, but it was worth it. And it was very emotional for me. Like, I literally cried. My brother saw it. My brother came in as my lawyer. And I was brought here when I was 7. I was born in Germany, and I don't know anything but America, but the immigration laws have been very tough for me and my family. And finally, I'm in, and I'm proud to be an American.
Fucking A, dude.
Congratulations.
I'm going to try to share the seat. Can people see my screen?
That's me. There we go.
There's my boy right there.
Yeah.
Come on, look at that.
Yeah, that was Wednesday. That was Wednesday.
Look at A, dude. Congratulations.
Thank you, Mike. Appreciate it, man.
That's so great. Congrats. So I got a lot of stuff to talk about. I do want to say that a lot of people reach out to me and ask to talk. And I just want to say that I appreciate people doing that because, you know, I am a true believer in you give unconditionally, ask for nothing back, you get back 1,000-fold. And I want to say that anybody who says, thank you for me helping them, you actually are helping me at least as much, if not more. And so the repetition, the going and over it, you know, everybody, including me, needs to hear the same shit that I say. And when I say it to other people, it helps me too. So I appreciate that. And, you know, Brianna's here on it. She's a clerk in my office for how many years now? A couple of years, at least 2 years. She's doing everything that I've told, you know, people to do. But what Brianna's done is she hears it, she says, oh, it's great, but then she's followed up, and she's followed up for years. She's read the book, and she is 7 months pregnant, going to give birth in a couple months, so congratulations. And so we talked this morning, and, you know, going over some stuff actually gave me some ideas about some stuff we want to talk about. But I want to just go over again the idea that 90% of people don't do stuff, 10% do. It could be even 95.5. And that's a great thing. It is, I have come to believe that it's a universal truth that 90 to 95% of people, even when they hear something really good, even when they hear something they agree with, more often than not, don't do anything about it because we all have lives, we make excuses. Remember, you can't cheat yourself, but we do. At least we think we do, but you can't cheat yourself. And I want to just give another example, just another example. Look, I'm giving a speech next week to Loyola, to the Consumer Law Group. I'm going to say the same shit I've said for the last 7 years about how to network and about how to follow through and how to follow up. And every student there is hardworking, smart. You know, they are ambitious. They all agree that what I'm saying is dynamite information, and 9 out of 10 won't do anything about it. So yesterday I was on a COC thing. It wasn't a lot of people. There were like 30, 35 people. Me and Dolan and a couple other people, a couple defense lawyers, Keith Brimmer. And it was about how to network, how to learn, how to make contacts. This is how to make contacts. And I say the same shit that you guys hear all the time, right? But I'm like, you got to write notes. You got to follow up. You got to think outside the box because everything you want is outside your comfort zone, right? Everything that we want in our lives that means something to us is right outside our comfort zone. 30 people. I'm telling them, if you hear somebody that says something you like, follow up with them. Like me, out of 30, how many people followed up with me? One of them is Boris. Now, I told Boris, take as many shots as you can. because you never know. I made an offer to people. I said, you know what? Let me see your resume and I'll help you figure out your resume. One person, Boris, took me up on it. He sent me his resume. I'm about to send this back with comments. I told him about whatever. He's going to get a job. I'm also telling him who to send it to. And I'm also saying what to say. Now, when Boris reached out to me, he didn't know I knew all that shit. Most of us don't know what we don't know when we reach out to people, right? And out of 10, 7, 8 ignore you, don't respond, don't give you much. 1 or 2 give you what you think, but 1 usually blows your mind. So I just want to keep coming. Do that 100 times, 1,000 times, right? I was telling Brianna, every one of these I sent out, we've got now, sent out about 450 of these. Everyone who's gotten one from me got a little note from me, right? Now, what did that cost me? Was it a pain in the ass? Yeah, I hate, I'm like, Catherine, I hope this helps. Yeah, you're like, what does that mean? But you know what? That 6 seconds that it took me, 8 seconds that it took me to write, and the prior thought to have the actual cards turned this into, oh, great, his assistant must have sent it to me, to a personal outreach. And what did I get that I didn't expect? People are sending me photos of my book with their card. You never would have sent me that without that card, but I didn't even think about that. But then people are like, oh, I want a book because people are you never even know. But what is that an example of? It's an example of taking the extra step. Yeah, is it a pain in the ass to write 450 cards? Yeah, I've already forgotten I've done it. That's over. But the benefits, the relationships that we all can build by that little personal touch in every relationship that we have. 2 people out of 30 yesterday followed up with me, but I'm writing personal notes to every motherfucker on the group. Not because I'm some genius or I'm some better or not or whatever, but I understand that this is another opportunity to solidify a relationship. So we've talked about networking. We've talked about building your community, building your circle. Every day we have opportunities to reestablish, to reconfirm, to reaffirm a relationship. And we don't do it because we're not thinking about it in that way. So I just want to tell everybody again, think about outside your comfort zone, outside the box. How can I reconnect? How can I write a note? How can I follow up? Right? And again, it's not about doing it the right way. It's not about, oh, well, I'll only do it if I have pre-printed stationery and I write on the note. If you can't do that, an email is better than no email. A text and an email is better than no text or email, right? A note on blank stationery is better than no note, right? And so I see these excuses. You can't cheat yourself. Oh, I'll write it when I get my stationery in 2 weeks. Stop it. You're just coming up with reasons for excuses. And I'm not being critical. I'm just pointing out stuff that we all do. And what happens is we kick it to next week. And then next week, we kick it to the following week. And then the next week, we forget about it. Huh? And it happens to all of us. And so I just want to reconfirm this because people are asking me, and I'm doing seminars on how do you network and how do you get business and how do you stay relevant and how do you stay. But thank God, and this is a perspective, thank God it's not easy. Thank you. It is a blessing that it is not easy. Because if it was easy, then everybody would do it and we didn't have an opportunity to stand out. So the fact that we can do even this little bit of hard work outside the box allows us to stand out among all of our peers. Thank you. What a blessing. And so, again, I want to now dovetail into, and I know we'll get to law in a minute, perspective. And I was talking to Brianna about this, and we were talking about, routines and how COVID has interrupted our routines. And then we were talking about perspective. I want to talk about that for just a minute. And I just want to re-go over some stuff that we talked about. One of the big issues in COVID that I have seen is that it's interrupted our routines, right? And now we work in a bathrobe instead of a suit or nice clothes. And you're like, well, I'm going to work in my bathrobe. And what we don't realize is that the bathrobe, even unconsciously, signifies to us something different than what a suit does, right? And so when you put on a suit, you're not putting on a suit just to look good. You're putting on a suit to get into a mindset, right? You're going to a workstation and an office, not just because it's where you work, but it puts you in the mindset. And one of the things that COVID has done, and it's disrupted our routines, right? We used to get up, we would drive to the gym, we'd work out, then we'd get dressed, we'd go to the office, and we're like, wow, we get all this stuff done. And now with COVID, you can't go to the gym, and then that doesn't mean you put on your suit, which you don't go to the office, and the next thing you know, you've interrupted your routine. And then this happens in a month, and then 3 months, and suddenly a new habit develops that makes it hard to get over. And so one of the things I have found that's very effective, Mike notwithstanding this morning, is try to think about routines and putting yourself in a routine, not because you want to accomplish something, but because it puts you in a mindset. It's the old thing about, why do we make our bed every morning? When I hire somebody, I ask them, do you make your bed every day? They're like, are you a weirdo? I'm like, no. Why, do you care if my bedroom is clean? I'm like, not really. Neither do you. You know what? You'll go to bed at night and jump into bed whether it's made or not made. But what it tells you when you make your bed every day is that you're the type of person that believes in routines and, right? Now think about it. Does everybody brush their teeth at night? You even think about it, most of us. No. When you drive to work, how often do you get to work and you don't even remember how you got there, right? And that's because it's become such a habitual routine that it's not even work for us. It's just part of that. Now imagine doing that with other parts of your life, going through your cases. Just every week I go through 3 cases and I look at, has the plaintiff been deposed? Has the plaintiff had an IME? Have I noticed the defense depo? Have I called my clients to get photos and videos before and after? Have I gotten all the medical records and sent them to the defendants? And that becomes a habit where it's not even work to you anymore. Suddenly you're making a shitload more money. Suddenly your cases are settling more often. Suddenly defense lawyers are referring you cases because they respect you and you're like, what's going on? Imagine making that commute the same thing as working out or going on a date night or spending time with your kids. Okay? Now, so Brianna, I'm talking about this. Sorry, Brianna, I know I'm bringing you into it. And I'm like, look, but I'm not here to preach because we all fall off the truck, right? We all think, oh, Mike, this is great. I'm going to do it. And then like 10 minutes from now, you're like, what am I doing? I get it. We all are like that. And the point is that you don't do it perfectly or you don't do it the right way, is that you keep trying. Everything that any of us have ever accomplished, we have accomplished not like this. We've accomplished it like this. Everything in the world, by everyone in the world who's ever done anything, has done it like this. Right? And understand that this is a failure. It is a slip. It is a step back. It is a shot that misses. It is, I don't feel like it. It is whatever excuse. And it's okay because it happens all the time. And that failure is going to happen to us multiple times a day for the rest of our lives. So how do I get to here, Mike? Well, it is many times how you deal, not with this, but how you deal with this. Right? And so I want to say about perspective that how you deal with this can be three ways. This is a fact. It happens. It's going to happen to every single one of us, probably another 50 times today. You look at it three ways. You can look at it negatively. You can be neutral about it, or you can look at it positively. What do I mean by that? Negative. I knew it was going to happen. See, I never should have tried. I'm a failure. What a waste of time. Fuck, I knew it. Or you could be neutral. Whatever. Or what I have tried to do, and it really helps me, positive. Fucking A, I failed. That means I'm working hard. That means I'm taking shots. Fucking A, I failed 10 times today. I am on fire. Now, which of those three makes me more likely to get back on the horse and go again? Now, the same facts, it's all identical, but how you look at it makes all the difference in the world. And what I want to say again is failure is not an identity. It does not have to be an identity. It is an event. And start to think about changing your language, changing your thoughts to failure is a good thing. I'm not saying it's fail on purpose, but you're going to do it. How you look at it means whether you get back on the horse or not. And maybe 1% of the time you change your language, but then next week it's 5%. And then maybe 3 weeks from now, it's 30% of the time. And maybe in 3 months, it's 70% of the time. And you will see dividends. You will see it, right? And remember, greatness is not for the chosen few. It is for the few. Look at us. It's for the 2 out of the 30 who choose to do the hard work that it takes to be great. And Boris is a great guy. I don't know him that well. I just met him. He's smart, right? Clearly. He's ambitious. He's in law school. He does what, but I don't know him. He may be dumb as a rock. He may be the greatest, smartest dude ever. What I do know is he knows how to fucking execute. And that is the most important factor in his success times 100, right? And I say this like I said last year in Vegas. Well, didn't that seem like a million years ago, by the way, the convention last year? Giving a speech on closing argument, right? And Mike the yogi now, I used to talk all about closing. And then I stopped about 20 minutes into my speech and I'm like, you know what? Let me just talk about what's really important because, you know, I've been around for 30 years. I've tried 100 cases. You ain't trying a case every month, right? It's not happening. So this is more important than learning about closing. Is that there's 800 people in this room and we're all smart. We all got through law school. We all are ambitious. We all know how to work hard. 10 years from now, we come back and about 2% of us are the ballers. And the rest are looking up to the ballers and going, God, that son of a bitch, they're smart, they're talented, they're good looking, they got family money, they got a lucky break, man. How'd that case get to them? That helps. But 98% of the reason those ballers are the ballers is because they understand that incremental, ordinary, but consistent behavior over time is what makes them great, right? It's that looking at your cases every day. It's that sticking to your routines every day, right? Like I said, 2 years ago, when I came back, had lost all this weight, right? A bunch of guys in the 50s, my age, are like, dude, how'd you lose all this weight? What was the steroids? The drugs, right? The weight loss surgery? How was the gastric bypass? And I said, without being facetious, I lost it an ounce at a time. And I know that ain't sexy. I know it sucks. I wish that I had the magic elixir that I could tell people and we could all get to be rich as fucking one day. I get it. Doesn't work that way. It doesn't work that way. So now get over it and now get on the horse and start working. Right? And what I love about this group is I see everybody not only gets it, but I see all of y'all doing it. And I see, and I'm not going to out a lot of people, but I have seen in so many of you, even when we started this process, to now make light years changes for the better in your lives and your outlook, right? And I won't use names unless he or she volunteers, and they don't have to. But I remember a couple months ago, somebody being unsure of what to do and how to approach things and how to look at things. And over the last couple of months has developed to a point where they're writing blogs on how to execute. Right? I am going to out them. Catherine, you did that, right? So
Yes, I did. Thank you, Mike.
when we first talked a couple of months ago, you were looking for some solutions. That routine had been throwing you for a loop. And now 2 months later, through consistent work, you've read books that we've talked about, you've talked to your kids, and now she's giving advice to younger people to do the very same thing. That took 2 months. 2 months. Imagine what all of us can do. All right, so I'm going to stop preaching, but this shit works because it's real life, right? Kudos to you. Moss, fucking stuck with it, motherfucker. Congratulations, being a citizen, right? How many people give up on that? How many, right? How long you been in the country before you became a citizen?
27 years. I had nowhere to go, though, Mike. I had nowhere to go.
Own it, brother.
And I was ordered deported, but I stayed.
Own it, right? Kudos. So let's talk. Hey, guys, would somebody turn off the koi pond, the hose? Sorry. Thank you. See, we run a classy operation here. So I want to talk about a couple of things that people have asked me about trial work, right? And I know we last week, Malasek, I think you told us on the listserv, they were talking about stuff that's filed 2019, 2020 is getting kicked, no trials to 2022. We've already started seeing that. We've had stipulations that are getting crossed out, and the hub is now putting 2022 on trial dates. The same is going on with San Bernardino. Riverside looks like they're trying to do some remote trial work, which has got a whole host of issues, which we're going to see how that plays out. But I want to talk a little bit about two things today. I want to talk about trial work, and I'm going to give you all some examples of what I'm talking about. But people ask me all the time, you know, what makes a good trial lawyer? What's the greatest thing you need to know to be a good trial lawyer? And I say the single greatest skill is heartbeat control. Heartbeat control, right? Now, some people like trial work, they like cross-examination, and some people don't. And there's no right way, I will say in we all know this, in Cala, the trial lawyers have been the king of the top of the food chain. It seems like we all get the kudos and the masters and whatever, but no, there's a hell of a lot of great lawyers that don't try cases, right? But people who try cases seem to get it. And everybody's like, oh, so teach me the secret. Show me the closing. I want to come to your closing argument and watch you so I can figure out how to get people to give me money. To which I say, why don't you come to a depot? Because 98% of your cases will solve before trial, and the depot is the most important thing in your depot. So you'd rather be a better depot taker than a better trial lawyer, but let's put that aside for a minute. Heartbeat control. If you can't control your heartbeat, you can't deal with the unexpected stuff that comes up in trial. And the only thing you can expect at trial is the unexpected, right? So when you're picking a jury and you go, look, How many people think there are too many frivolous lawsuits? Look, I need people to tell me if you hate plaintiff's lawyers, I need to know that now, not when you're deliberating. Does anybody hate me? And when somebody, which happens all the time, Mr. Adler, I hate your ass. That's happened to me many a time, right? Now, how do you deal with that? If you can't control your heartbeat and you're like, oh, flustered, you cannot think, right? You can't think. And then suddenly you're like reacting emotionally, and now you're going to argue with this person like, no, I am a good guy. No. What are you doing? If you can think, then you can use that to your advantage. Like, for example, in a voir dire, you're like, look, that's exactly the kind of stuff I'd love to hear. Thank you for telling me that you hate me. I really appreciate that, because you telling me you hate me tells me that you're probably not the right type of juror. And now you can react in a way that makes other jurors who hate you more likely to tell you they hate you, right? And if you couldn't think because your heart's beating so fast, or the expert that throws you a curveball, or when you think you got the greatest cross-examination and you ask the Perry Mason, I'm surprised people don't know who Perry Mason is, but I'll talk about Perry Mason in a minute. But you ask that, and isn't it true, doctor, that you are now impeached? And then they've got a good answer and respond. You're like, shit. How you deal with that is primarily a function of heartbeat control. And as an aside, Perry Mason, I know anybody over the age of 40 probably knows who Perry Mason is. But so Perry Mason was a TV show way back in the 60s. Was it Raymond Burr. And his name was Perry Mason, and he was a lawyer. And it was a trial show. And they always had a trial where Perry Mason would be at the end of the trial, would have the Perry Mason moment where the person would admit they were a liar or admit fault. So the end of every show was like the lawyer go, and isn't it true, sir, that in the foyer you actually picked up the pistol and shot them in the face, unlike what you're saying now? And the person would go, you're right, I was a liar. And that was called a Perry Mason moment. That became synonymous with the cross-examination moment but I realized that as I've gotten older and I say, oh, I had a Perry Mason moment, they're like, what? So that's what a Perry Mason moment is. So I may have said this before, but I want to give everybody an example of what happened in a real trial. And if you all have already heard this, just get over it. But here's what happened to me when I started out my practice. I had just probably a year or two into my own practice, and I'm trying anything that moves. And I was getting cases where I would say, look, I'll take any case that you have. And I remember a guy who's no longer alive. He referred me a case, very elderly lawyer. And he comes in, and it's a young girl, 17-year-old girl who gets into an accident and has like either a meniscus tear or something, has a knee surgery. She's telling me about it. I'm like, all right, I'm trying it in Norwalk. And he's, all right, Mike, you got the file. Okay, man, see you later, whatever. And then he walks out and he goes, oh, but just remember, ask the treating doctor about his probation. All right, Mike, see you later. And I'm like, wait, what? True story. And I want to ask y'all how you deal with this. If you've heard this already, you can get over it. So the doctor who's the treater was an Indian doctor with a very thick accent. And I remember we're trying the case in Norwalk against a great guy. I don't know if he's still alive, but he's retired. He was an in-house counsel for Allstate, James Christensen, good guy, but kind of would take it easy, right? Not a hardworking type dude. And we go to Friday, and then I'm going to put the doctor on Monday morning. So I talked to him on Sunday. He's got a very thick accent, hard to understand. And I said, Doc, what is this thing about probation? I'm not going to do it in the accent, but it's like, imagine a very thick accent. He's like, I came to this country and I couldn't really speak English very well. And I took the medical board and I didn't pass it. So they put me on probation, and then I passed it and they took me off probation. I said, if they ask you about it, just say that. Good. So I put him on Monday morning, go through direct. I'm like, sit down. I don't ask about probation, just about the surgery and whatever. And I sit down, and I'm like, I am a fucking genius. I'm like the greatest trial lawyer ever, right? I'm like, you're a witness, sir. Defense lawyer. Sorry, guys, I'm in my. Your Honor, doctor, true story. Doctor, isn't it true that you are on probation? Oh, I don't understand. Sir, what is that document in front of you? I do not understand. Sir, that is the Attorney General's indictment of you for unnecessarily operating on 6 different people, and you are now on probation. Isn't that true? Oh, it is true. I am on probation. And he sits down. I know some of y'all have heard this, but don't answer. Mike, you're a witness. Here you go. All right, guys, what do you do? Unmute yourself and tell me what to do.
Make it seem like an honest mistake.
You believe that? Keep going. What do?
You tell them, hey, but my client isn't one of those patients.
Good answer. That's exactly what I did, right? But again, this is a perfect example of, I had no idea about this, right? Like, so now they blow this out of the water and the unexpected. So the first thing I did was, I'm trying to look like it's not a big deal. So I'm like slumped. I'm like, oh, wait, are you done? You know, first thing you got to do, I was like, I had to let the jury know that I wasn't a part of this. So I'm like, man, I didn't know about this. Objection. And then that's the thing. Chris, good point. But see, now this is what heartbeat control is about. Stuff like that happens in trials, and you got to figure out what to do. So I walked up to him and I went, sorry about the shorts, guys. I'm like, okay, sir. You're on probation. Thank you. My client's not hurt. No. Oh, no. She is. I'm like, no, sir. You are on probation. My client's not hurt. No, she is. Sir. Oh, wait. That's right. He didn't ask you about my client. Thank you, sir. And what's that an example of? It is the example of giving the jury an out if they want to vote your way, right? And that's what happens. If you retain your credibility, even when your treating doctor lies on the stand, is on probation for falsely operating or doing unnecessary surgeries, I got a plaintiff's verdict. And afterwards, what did the jury say? Oh, yeah, but they didn't ask about your client. And that was the reason. It's like now, and I'm not going to be political, but I remember I was we were on a trip, went to the Montage in Orange County this weekend. Some guy in the pool, loudmouth. I'm sure he was driving his Ferrari in, buffed and like bald and like talking on the phone really loud. And I hear him, I was like, man, Trump's an idiot. He's just a dumbass. But I can't vote for Biden because he's a socialist. And what's an example of that, right? It's the reason why he will vote for Trump, because they gave him a reason. Oh, Biden's a socialist. And that's the way a lot of times people make decisions. If you give them an out, an explanation, a justification, they will use that. So he couldn't say, I like Trump, but he's going to vote for Trump because he's able to say, I can't vote for Biden because he's a socialist, right? The jury is going to vote for me or my client, whatever the reason. And I remember when I started working for Mike Hughes, my mentor, he had a plaque. And he said, let me tell you the secret. He said, to being a good trial lawyer. They like the plaintiff, you win. If they don't like the plaintiff, you lose. Get the fuck out of the way. That was his, and in many respects, he's true. He's right, because people look for reasons why to vote certain ways. Does that make sense? Okay. So in the book, I wanted to tell you guys that I wrote an article on the formulas to use in opening and closing. And I was talking about this. a lot of people think that to be a good trial lawyer, you have to be a great orator. You have to have these amazing ideas. And most of the time, that's not true. Most of the time, people aren't Barack Obama or JFK or anybody, right? We're normal people. And what we forget sometimes is that we try to be Barack Obama and we're not actually communicating to a jury. And what I put in the guidebook and what I wrote about opening and closing is that there's a formula, and take a look at it. And if you want to be, an 80% good opening or closing argument, you can follow this formula, right? In an opening, for example, the jurors don't know your case. They don't know that Mr. Harris is so-and-so. So every time you use Harris, unless you put it into context, they don't get it. So a lot of times trials are about boxing in times, boxing in names, and continuously reminding the jury. And I do it in depot too. For example, sir, when the plaintiff had an MRI in March as a result of the January accident, right? So you're telling the jury what the context is. Sir, when Mr. Harris, the driver of the other car, did whatever, you're putting it into context. And so often I see people in trial be overly emphasizing their oratory skills. Now, they've been with the case, the lawyer, for 3 years. The jury has known this case for 3 minutes. They don't know the names. So a lot of times in opening, I'll write the names with who it is, right? I always, when I say a name, say who that person is. When Dr. So-and-so, the plaintiff's primary treating physician, said the following, right? When Mr. So-and-so, the witness who was at the accident, said the following, because you're constantly trying to give people context. Does that make sense? Do it in depot. A lot of times your deponents don't understand the context, especially if they're a person most knowledgeable, which is why I love bringing in whiteboards where I can write the date of the accident. When I get names from the PMK, I will write them on the whiteboard and I'll write who they are. Not only do I forget, but it also helps the witness put stuff into context. It's also a great way when you write up the names to then go back and make sure that you follow up on each person. Like, did they give you any documents? Did you text with that person? Were they a part of that conversation? What happened next? It's a great way of organizing stuff. Okay. So try it in your depots. Now, I know remotely it's harder. I get it. I do get that. And, a lot of depots that the techniques that we used in person that were so effective are much, much more difficult when you're doing it remotely. But again, hopefully the governor's going to sign this, whatever this rule or this bill is, to make remote depots. Didn't I mention this last week? By the way, guess what happened? In that case where I said that big case where the defense lawyer wouldn't do the depots remotely because he's so important, judge just ruled this week that they has to do all the depots remotely. And what was the ruling? It was, look, who knows when this is going to end? If you keep sticking to that, you'll never get anywhere. So get on the stick and get with it. And then he commented on Governor Newsom's about to sign this bill. So if any of you all have a lawyer on the other side that's sticking to, we can't do discovery because it has to be in person, use that governor's thing, and at a minimum say, well, okay, we'll hold off another 2 weeks. But if he signs it, you have to stipulate that we can do everything remotely immediately. Right? Think about that. Okay. So the same thing with opening happens in closing, right? I see these, these lavish orations or whatever about, let justice be he to whatever. I'm going to quote Ecclesiastes. You're like, what? That's great if you're like on television. But what does a jury need to know in closing arguments? They are in the back deliberating. So what your primary role is to explain to the jurors who are going to fight for you, your warriors, how to go into the back room and fight for you. And you explain literally, this is what's going to happen. There is a burden of proof. Here's the law. The burden of proof says more likely than not. So you put the evidence on one side versus the other. And here's the evidence. So when you go back, the defense made this argument. Hey, people who are going to vote for me, here's what you say when the other side says, yeah, but the plaintiff was pre-existing injury. You say, but that was da-da-da-da-da. You're literally teaching your warriors how to go back into the back room and fight for you, because that's what's going to happen in the back room, right? So I see a lot of lawyers have this image that the trial lawyers that are really successful are these magic makers that like trick people, and that shit's not true, right? I wish I was a magic. No, you understand what's needed. Now you can fluff it up and you can, talk with a Southern accent, which some people have been known to do. But at base, what you are doing is you are teaching the jurors how to vote in your favor, and they need that information, which is why you show the law, you show the exhibit. You don't make them trust you, because the people who don't like you are not going to trust you. Oh, Mr. Alder said the MRI said 4 millimeter, but that's not what I remember. So you got to show it to them in closing. See, it says 4 millimeters. So that when that person says, yeah, but Alder's like misrepresenting, and then they go, no, he showed it in closing. What are you talking about? You got to anticipate what the other side's going to argue and have the weapons given to your warriors to fight for you in closing argument. Does that make sense? I'm sorry to bust the bubble that, at some point there's some magic bullet out there that you suddenly become a preacher and you now win all your cases. That shit it's not real. And anytime you see on the listserv, I took a $15,000 whiplash and made $50 million, that's bullshit. I'm sorry. Doesn't happen. Maybe it happens 1 in a million. But like I said, last year, people said, Mike, how do you settle a $20 million case? And I said, first thing you do is you get a $20 million case, right? You don't make cases out of nothing. And one of the things that I've done in my practice is I've realized that sometimes a good settlement is not necessarily a large number. It's a good number for the case. And we all have different types of cases. And I see some people hanging on to a $15,000 case because they really wanted $17,000, and they'll hold on to it for 9 months. Settle the goddamn case for $13,500 and move on with your life. Your client will really thank you. And that's how you make money. Last thing I want to say today is there's another article, and I just want to go over it since we mentioned the cases. I wrote an article that Malisak pointed out that I did a long time ago when I was a much younger person. The cases that we should know to be trial lawyers. And I just want to go through those one more time, and I want to add one. And I think if you guys, you've seen that if you know the cases, if you can name the case, and God forbid, if you can spell the case in a deposition or in court. I've done it with judges. I'm like, Judge, the seatbelt law doesn't apply. Truman versus Vargas. I think that's TRUMAN versus VEAGA. The judge is like, oh, that must be true because you can spell it. It's silly, but it actually works. So let me just tell you, where is it? Here. So everybody knows the two big cases you need to know in Depot, right? Stewart versus Colonial Western, which is you can get an answer to any question other than privacy or privilege. It is the standard. And that's STEWART, not STUART, Madam Court Reporter, Mr. Defense Lawyer. But the other one is Emerson Electric Company, which says that you can make a deponent write out a schematic and or act out. And the same with the plaintiff. How were you thrown about the vehicle? Show me how you punched the plaintiff. Whatever. And you can make them get up out of their seat and go right on a whiteboard, which is very effective in person of taking control of the depot. If you're standing up, you can use Emerson Electric Company to get the deponent to stand up and come over and talk to you. Let's all go on the board. Like I said, I've had many depots where me and the defendant or the deponent are standing at the whiteboard and the defense lawyer is like 30 feet away. Guess how much I controlled that depot, right? The next one, okay? Schreiber versus Kaiser. This is on page 10 of my book. There's a difference between a designated expert and a non-designated expert. And it's important. And then Sanchez has really kind of geeked this up. But the difference is Schreiber, okay? If you designate an expert, that expert, let's say a doctor, subject to what we'll talk about in a minute with the Sanchez requirements, which has come up in the last couple of years, but used to be that if you designated a doctor, they could talk about anything. They could talk about past, future. They could talk about care, past, future. But what we do is we have non-retained and retained experts, and we listed all the non-retained experts. Well, a strict adherence to the Schreiber case, which happens with good defense lawyers, is if you don't retain the expert, when you ask a treating doctor who's been a non-retained doctor about care of some other doctor, they will object on Schreiber and say they can't give opinions about other doctors, other care. They can talk about their care, right? But they can't talk about it in general. Whereas if I had designated that treater could also talk about everybody else. Now, sometimes you get away with it because the people don't know. But if you got a good lawyer on the other side, you got to be careful. Because if you don't designate your treater and you have a plaintiff that has care from a lot of other doctors, your treater may not be able to talk about the other care. It's less important if, like, you have a knee surgery and the only real doctor is your treater, you don't have to worry about it so much. And sometimes you don't want to designate them, so you can say, you're here as a treating physician, not as a designated expert. But if you need that treater to be able to talk about other stuff, you may want to consider designating them, even though they're also a treater. Okay? It's a Schreiber case. Next, Allen and Stony Brook are the two cases that talk about if you are an expert witness and you get more than 50% of your income from forensic work, you have to tell the other side how much money you make for at least the last 3 years. Okay? So Allen, A-L-L-E-N, Madam Court, Stony Brook, S-T-E-N-E-Y-B-R-O-O-K, 1, H-O-A. Look, I know I'm doing this and it sounds silly, but if you can spell these cases, it is like a sea change. People are like, wait, you must know this case because you know how to spell it. It is silly. I get it, but it's real. It's like having real half and half at your depot rather than powder. All it tells us really is that you spent $1.25. But what it means to some people is you're big time versus rinky dink. It's silly. I get it, but it's real life.
Mike,
yeah.
Practically, do you do that though for the money one? Or do you get like everything you need and then you try to get it at the end? Or
when I was younger, I would file motions to compel pre-depot and all this other. Now I have so many depots in my repertoire that, in my library that I know the answers. And again, you decide if you're in trial and you have that information, okay, if your experts that make more money than the defense experts get crossed on money, then you may want to do a less intensive job just to show that everybody makes money. But if the defense lawyer lets it slide and there's no cross of your experts on money, you may want to run hard. And a lot of times, if a defense lawyer, remember when we talked a couple of weeks ago about questions that you want to ask experts that you hope they don't answer because they look worse not answering the question than the answers they give you? Money's a big one. How much money do you make? I make $650,000 a year doing it. You're like, fuck, I didn't want to know that. I wanted you to tell me I had no idea, because that is not truthful, right? Most people know generally how much money they make. Right? So sometimes when I have an expert who's like, that's objectionable, I'm not going to tell you that. I know when I ask him that in front of the jury, if he says that shit, I go, Judge, can you make him tell us? Especially if he then says, well, you have to establish. I'm like, dude, you make more than 50% of your income. He goes, I had no idea. I'm like, you're telling me that to avoid telling us the answer. Of course you know how much. And then I have a cross that has nothing to do with the case. That's dynamite, because this guy doesn't want to give you an answer. And now you have the argument to the jury. How can you believe him? He's clearly able to lie when he doesn't want to give you an answer that doesn't help him. Right? So it just depends. That's the answer. So Howell, obviously, everybody knows Howell, right? Howell is the paid specials or the owed specials are only thing admissible. Now, I've been around where it used to be that what was billed was admissible. Then it was what was billed was admissible, and then post-trial, the judge would reduce the specials to what was paid. Then Howell came down and it said, nope, you can't even put on the bill. So what does that mean? It used to mean when your $1.1 million Medicare bill was $75,000, you could at least put on the 1.1, and then post-trial, the judge would kick it to 75. But the jury thought you had $1 million worth of medical bills, so you got more pain and suffering. Howell said, no, you get to put on $75,000. So when that came down, we had an initiative and we were trying to change the law. Now imagine how much money the insurance company was willing to spend to keep it. They saved literally $100 billion a year on that change of the law. We could not put a dent in that. They were willing to spend unlimited money. They gave money to every politician in California and said, we will keep it coming forever if you just don't change Howell. So it's the law. Next, Pebley. New case coupled down a couple years ago, right? There was an issue about whether insurance comes in, and a lot of judges, especially new judges, especially DAs that didn't understand civil law, would be like, well, why isn't insurance relevant? They didn't use insurance. And it was a killer. So Pebley, at least when it's read right, precludes the fact that your client has insurance, whether they use it or not. If they go lean and they have insurance, just as a caveat, understand that if your client has Kaiser and there's Kaiser all over the medical bills, sometimes you may want to get ahead of that ball and talk about Kaiser in voir dire and say they have Kaiser and they haven't used Kaiser, because what you don't want is to not talk about it. And you can't strip all the records of Kaiser and they see Kaiser, and in the middle of the trial, when you don't have a chance to voir dire those people, they see Kaiser, and then those are the people that don't vote for you, that you could have weeded out in voir dire if you had talked about the fact that they had Kaiser, didn't you? So be careful. For HMOs, especially Kaiser, a lot of people understand, well, same with workers' comp, right? Well, they have comp, therefore they're already covered. Now they're just greedy. Got to make some game time decisions. All right, Sanchez, people versus Sanchez. I just want to go over this, okay? Remember when I told you about the trial with the Indian doctor? It was easy back then. I used to take cases. I've taken cases the night before trial, and I could deal with it because my experts could say anything they wanted to, right? I could make them talk. I could argue because hearsay was not objectionable for an expert. My expert could talk about other people's records, and when they were designated, it was almost as if the hearsay rules went away. So a couple years ago, Sanchez, in a criminal case, a expert in a gang case said, oh, I read a gang report, and these defendants were part of a gang, and that came into evidence, and it got reversed because they said, well, that was a hearsay document, and the expert can't talk about hearsay. That then got applied to civil cases. And what Sanchez now means is that you have to, even with an expert, adhere to the underpinnings of hearsay before an expert can use that information. They can rely on it, but they can't talk about it. So it used to be that a defense expert could say, well, based on the ER records, it appears that the so-and-so said such and such and did whatever. Well, now with Sanchez, that defense expert can't talk about what was said in the ER records until they establish foundation for that statement. They have to call the nurse who wrote it down. They have to call the doctor who wrote it down. An accident reconstructionist can rely on the police officer's measurements, but they can't say what the measurements are unless the police officer comes into court and says, I measured, it was 23 feet. Then the expert could say it was 23 feet. So you can imagine the sea change difference that this has made in trial work. For example, now you have to, no longer can you take a case, a referral last minute, because if the lawyer hadn't done the basic foundational stuff to get over hearsay, my expert can't talk about the police report, what's in the report, or the records, or anything. So now when you have a case, you have to look back from the trial 6, 7, 8 months, talk to the defense lawyer and say, hey, do we need to take that police officer's depo? Let's stipulate away Sanchez and both agree that our accident recons can use all the information. Hey, let's not take the 7 treating doctors' depots so that our experts can talk about it. Let's just stipulate that both sides can do away with Sanchez. It's a big difference because sometimes you want to stip away Sanchez, but sometimes you don't, right? Sometimes there's a statement in the ER that says plaintiff denies pain. Pre-Sanchez, the expert goes, the plaintiff denies pain. Well, now we get to say, well, who said that? Who wrote it down? How do we know that came from the plaintiff? Your expert can't mention it unless you find the person who wrote it and got from them that it came from the plaintiff as a party admission. Other than that, that shit doesn't exist. Everybody see those distinctions? I know this is a little technical and it's getting in, but Sanchez is a big deal to a point where both plaintiffs and defendants are like, can we pass legislation to get rid of Sanchez and go back to the old law? Because it is a huge, I've talked to good friends of mine who are judges, plaintiff lawyers who are now judges, and they're like, it's a nightmare. If the plaintiff and defense don't stip away Sanchez, and a lot of defendants won't, and it's a big case, I have 2 weeks of foundational witnesses just to get over the hearsay rule that I never used to have. So my 1.5 week trial is now 4 weeks, of which 2.5 is just boring ass shit. Is this your handwriting? Who did you get this information from? Did you write it down correctly? Did you follow the appropriate procedures on following your course in custom and practice? Over and over and over, right? It's a big deal. So you got to know Sanchez, and you got to know it in advance enough to know when you want to step away from it and when you don't. It's a big deal. I gave a speech to SoCal Defense. They asked me to speak 2 years in a row a couple of years ago when it came down because the defense bar was so freaked out about it because they're guys like foremen and Weinstein and all these people that used to just run rampant through the records, right? They would say, well, there's a record that says the plaintiff is a liar. Therefore, you're like, where did that come from? The defense lawyer wrote it in the record, but they didn't have to establish it had any foundation. So they would just run with it. So they were worried about now being unable to have their experts use little statements, in police reports and records to hurt the plaintiff. The plaintiff is worried about you have your expert who can't say what the MRI report says because you didn't call the radiologist to establish that the radiologist read it according to the custom and practice. I know this is technical, but this is real shit. I mean, this is what, last couple of cases and you know what? That's done. That's all you should know. Oh, the last one is just for Kelly versus New West. Kelly, it's a lot of judges like it. When you're doing motions in limine, motion in limine practice is not summary judgment practice. It is for a small group of anticipated evidentiary issues that need prior rulings. Everything else under Kelly versus New West shouldn't be brought. So when you're in a trial and the defense lawyer has filed 30 motions in limine, many of our responses are Kelly versus New West. This is not an issue that needs to be decided pre-trial. And a lot of judges are like, you're right, out. So before we end, any questions? I know I'm running crazy today, but a lot of good stuff. But I open it up to the floor. Mas, again, congrats, brother.
Thank you, Mike. I appreciate it. Thank you for highlighting it.
Really
Mike, I have a quick question. When you talked about, this is Sunny Koo, when you talked about heartbeat control earlier, I was watching a webinar this week about an attorney who had recommended taking beta blockers. What's your opinion on that?
Look, you do whatever works for you, but I don't know what beta blockers do.
It gets rid of your nerves and makes you calm and not well,
Is that what those guys did when they robbed the Northridge Bank? They took some type of pills. You remember that? And they basically, their adrenaline was so low that they didn't care that there was hundreds of cops coming after them.
Well,
never heard about that.
I say go at it naturally, but I don't know how to respond to that.
Okay.
Yeah, to be honest, I don't know. I've never done that, but I try not to drink a lot of coffee in trial. And sleep is really, really important. And every trial lawyer I know has a routine. My routine in trial has always been that I get up super early and I prepare for my day in the morning. So I'll get up at 4 a.m. and prep from 4 to 7:30, 4 to 8. And then at the end of the day, I'm out. I rarely look at stuff in the night. I just go to sleep and then I'll wake up in the morning again and prep. And if I'm trying a case with an associate who in the morning has already sent me, they work at night, they send me their outlines or whatever, and then I wake up in the morning and I start with that. And different trial lawyers have different routines that they use, just whatever works for you. But I try not to have a lot of caffeine, try not to drink, and try to sleep as much as I can. I have Mike Schoenbach, a very good defense lawyer, good friend of mine. He said the last thing that you ever want to do is break your routine while you're in trial. So he works out every day, never changes. And I agree with you. He's like, I have won trials where I'm losing at the beginning, but a week and a half into trial, the plaintiff lawyer who's out celebrating, partying, whatever, runs out of gas. And he's like, I'm steady, I'm steady. And that's a good way of dealing with stuff. All right, anybody else? Guys, have a good weekend. My chickens are laying eggs now, so I'm going to have a good breakfast. And thank you. I really appreciate everybody listening to me. It helps me as much. Hopefully it helps you, but it certainly helps me. So
thanks, Mike.
Thank you.
Thanks, Mike.
Bye.
Thank you.
Thank you.